Camera live.
Good morning. It is March 13th of Senate Judiciary. We're taking up S87. We have Todd Maywas from the Attorney General's office. Floor yours.
Great. Thank you, Senator. I wanted to touch on three things, I think, this morning. One is just in reviewing the latest draft number 1.1 of S87. We wanted to recommend one change in addition to what we raised in testimony 2 days ago.
Just to bring everybody up to speed, what did you recommend 2 days ago?
Two days ago, thank you, Senator, was adding corrections as another authorized agency for both holding individuals and then assessing the authenticity of pre-signed waiver and identification documents, mostly to increase the efficiency that this bill is attempting to provide for the extradition process. The other, on that note, turning to page 4 of draft 1.1, which is seeks to amend 13 VSA 4967. This is subsection C, or section C, subsection 3. I guess it's two, not three. My apologies. Subsection 2, so line 6. We would recommend including there that the documents that would be assessed by either the law enforcement or corrections agency could be received by reliable electronic means. So without clarity on that, we just want to make sure people can use email to send the pre-signed waivers and authentication documents. And this is a process that's used, for example, in PERPOs, the extraordinary relief petitions, and in certain warrants as well. And so happy to send language to Ledge Council for you all to consider, but it's just another suggestion to increase efficiency there so that if things are going, the demanding state is not seeking to get the documents, put them in an envelope, get them to the post office, get them sent to Vermont, get them picked up by VGS, get them to the corrections facility, and get them sent.
Yeah. And that wouldn't be able to happen via Odyssey because it's from a different state.
And I think generally, and I would look to corrections if you want further information on this, but I think they do a lot of that electronic communication anyway with sister agencies in other states. So it's just making it clear that would be, again, just a recommendation. The other point I wanted to touch on is just an observation on page 3, lines 1 and 2. In reviewing it this morning, we just had a question or maybe a comment with the amendment that sort of looks to take out gendered language by changing rights to right on line 2. The concern is just that, and maybe I should read the whole thing just to give it the context, but I'll start on page 2, line 21, kind of after the however. Before the waiver is executed or subscribed by the person, the judge shall inform the person of the right to issuance and service of a warrant of extradition and to obtain a writ of habeas corpus provided. Our only concern is that if right is singular, it makes it sound like both issuance and service of a warrant of extradition and obtaining a writ of habeas corpus are a right. Obviously, it's a right to petition for habeas corpus. It's a right to get the issuance and service. We just think making it plural makes it clear those are two separate things in judges and saying you automatically get a writ of habeas corpus. I don't think the other laws would square with that reading, but we want to just suggest that making it plural. I couldn't figure out better language.
I'm sorry, my laptop is frozen, so I can't look at the language, but she's, Kayla's getting a copy for me, so I will.
I don't think it's, again, it's a small thing, but we wanted to just flag it as like essentially consistency. So the last thing I was going to touch on, I'm happy to go back to obviously whatever the committee would like. There were questions last time about what's the scope and scale of limitations on returning people based on an extradition petition. We talked a little bit about comedy, we talked a little bit about privilege of communities. I think I want to just go back to Article 4 of the U.S. Constitution, Section 2, Clause 2. That's the extradition clause, and the extradition clause. We should have it here in front of me. I apologize. The extradition clause makes it a constitutional obligation of every state to honor a petition for extradition. The only limitation on that is if the crime in question in the other state is found unconstitutional or could be unconstitutional. So that's kind of the limitation on that.
Question for you, unconstitutional in which state?
Federally as constitutional.
Federally.
I mean, obviously it was struck down in the demanding state, it wouldn't have the force of law anyway. But that's the comedy issue, is that, right, Vermont court can't rule on Tennessee law. So I think there are limitations existing in Title 12, Section 7306B3. That's Vermont's what's known as Vermont's shield law, that legally protect the healthcare activity. And 7306 we appreciate as essentially saying, there is a limitation. So this is a carve out to the carve out. The carve out is non-cooperation under 7306, basically, that we talked about this in the context of S44, that public entities aren't obligated and cannot cooperate with federal entities or others around legally protected healthcare activities, except a public agency or employee, appointee, officer, official in the course of the only business is responding to a warrant or extradition demand on the good faith belief that the warrant is valid. So it's important to just flag, right? Warrants are already carved out, extradition is already carved out from the legally protected healthcare activity, but only insofar as it is valid in the state. And so that's the kind of wiggle room. But again, it runs up against Article 4, Section 2, Clause of the U.S. Constitution. So those are the kind of areas, not barriers, those are the guardrails around it. And I think that it's probably a longer conversation with Ledge Council about exactly where those limitations should be drawn. I don't think they're necessarily appropriate in the SE exception and extradition.
Well, I agree. I guess my question about S87 is it in no way makes it easier or makes it more probable that we might find ourselves in some of the positions that I've flagged.
I would say it doesn't make it easier, it makes it simpler. And so whether somebody is being held under a warrant here or in a sister jurisdiction, and again, I think there's an open question about the extraterritorial application of criminal laws. That's an open question now, meaning can Vermont criminalize behavior that occurs in another jurisdiction and then seek an extradition on that behavior if something's never actually been in Vermont. And that's the open question at hand right now. And so until that's settled, and that's the sort of constitutional, right? If it's found to be unconstitutional or constitutional, that would be the difference around any potential extradition petition. So that was the long answer. The short answer is no, I don't think it makes it easier.
Any thoughts in general on the several points that are raised?
No, I was just wondering how commonplace is it in Vermont to use the writ of extradition to sign off on? Is that used in Vermont a lot? Or
You mean to seek a governor's warrant?
in other words, someone come from another state signs off on it.
Okay.
Does Vermont do that a lot? Or?
I believe it is part of our parole, probation, and furlough conditions as well. It's part of the Uniform Act.
Thanks.
So we do seek it.
Yeah.
In terms of smaller change regarding rights versus right on page 3.
I'm looking at it and, like what we're trying to do there is get rid of like archaic language and gendered language and, we usually, when we're using the singular, it's not exclusive.
Yeah.
Right? And so in terms of like how we normally use statutory interpretation, I think it's fine. I get your point. You'd have to kind of rewrite that. I mean, I guess I'm wondering, I'd have to spend a little more time and like, did you write about that in your written testimony or no?
Because I just got it.
Okay,
I don't think this shows.
right.
I mean, is it in line with other statutes to use the singular in that way?
Yes,
Yeah.
yes. I mean, I think this is the way we typically draft. It doesn't mean that sometimes we don't, deviate from that if people feel as though there needs to be a little tweak in some circumstance or whatever. So,
Yeah, I'd like to remain consistent with what we have in our statute unless there is a specific issue that's been raised in a case where, a judge has cited a lack of clarity and it's, caused a certain outcome.
Right, and respectfully suggest maybe an easy edit is to simply repeat the phrase "the right." So line 2 would read, inform the person of the right to issuance and service of a warrant of extradition and the right. So in certain words, the right
happy to do that.
to obtain the purpose in that way. Both of them are separate rights.
I think that's fine. And I don't think I think it's the same as what's on the page from the meeting standpoint, but if that makes you feel better, I have no problem with that as a drafter.
Maybe get your thoughts on that. No. It's the electronic means, reliable electronic means on page 4 of sending authenticated copies of extradition waivers from the demanding state. Any thoughts?
I think that's a very good suggestion. Yeah.
Thoughts in general about this bill, and these changes made along with the change to that 90 days on page 1 and the extension of 30 days on page 2, what we discussed, I think, yesterday. With those changes in mind and everything we've discussed today, how are folks feeling about the bill? Yeah.
Go to the 90 days, off of 30 days, that's.
Yeah, I'm good with 90 days. But I think it's,
All right, well, I think we can get those changes drafted up and take a vote later on today. Okay.
Totally, it's just more of a computer.
So, no worries.
So they just gave me a new one, but it's not set up with all my stuff
Yeah.
yet. So, but I can totally knock that out. So the only changes I'm gonna make is add the right and then the electronic means, right? And everybody's good with it.
Right. Yeah.
Did you get the dates also, Joe?
Yeah.
That's already in the version that you guys have. Yep.
Great. So, yeah, we can break until 9:30 and then it'll be able to